Okay, that's acceptable.
Sorry, Dave, we were waiting on the other gentleman.
Gentlemen,
Yes, you're in.
Where am I going? Let me get on the air.
Go wherever you want to go.
Now we're up, down, up, down,
Yeah.
It'll be fine.
Are we good? You all right? Everybody here, we're good? All right, good afternoon, everyone. That didn't work. We'll start with this. I'm Dan Caulkins, State Representative in the 88th House District, and we're here today to talk about the unconstitutional gun bill law that we are fighting. As you know, we filed a lawsuit in Macon County challenging the constitutionality of this law. Last Friday, Judge Forbes issued a final judgment, and I'm going to use a couple of words here that are legal, and lawyers are listening in, and people want to know what's going on. You can ask an attorney. It was a Rule 18 order, a final judgment declaring the law unconstitutional. Now, the basis for our challenge was equal protection and special legislation, and those were the 2 points that we challenged in this law. And Judge Forbes, agreed with our points and issued the final judgment. Judge Forbes found that the law is facially unconstitutional. So the word facially means something to attorneys, and you can look that up as well. So the Attorney General has appealed, obviously. We expected the Attorney General to appeal this decision. He's gone to the Illinois Supreme Court because that is the direct appeal route. The Attorney General used the Illinois Supreme Court Rule 302A1. Again, this is a legal term that was used by the Attorney General. And in order to make a direct appeal to the Illinois Supreme Court under this Rule 302A1, the Attorney General has to agree that the law has been invalidated and it negates the very existence of the law and in all applications. And that is the essence of this appeal. So we're here today to talk about our Second Amendment rights that are under attack here in Illinois. And we want to talk, obviously, about this lawsuit. We're on track now to an appeal by the Attorney General, and documents are being exchanged and will be exchanged. And I believe we'll have our day in court in May. We look forward to vigorously defending this final judgment by Judge Forbes. We believe that we have the facts on our side. So with that, I want to, where do we go here? Yep. I want to get our friends from Illinois State Rifle Association to come up here, maybe have a couple of words.
You bet. Thank you. My name is Ed Sullivan. I'm one of the lobbyists for the Illinois State Rifle Association. We're here today just to put some credence and credibility to the determination that this is applied statewide, as opposed to the AG's interpretation of the law or of the ruling that it only applies to the said defendants. And so Representative Caulkins discussed a couple terms that I want to stress before I read a statement that kind of explains this a little bit more. Facial, unconstitutional as written on its face, versus as applied to a particular litigant. And so the statement that we have released from ISRA is, after reviewing with counsel the Macon County Circuit Court's decision based on how the decision is not explicitly limited to one named person or groups of persons, and based on how the opinion clearly finds the challenge law unconstitutional on its facial basis, as opposed to being unconstitutional as applied to any particular person or to all persons in the state. We acknowledge that the language therein also seems aimed towards facilitating an Illinois Supreme Court review, and we are confident that the skillful attorneys representing the plaintiffs will successfully present their arguments to that court at the appropriate time. Now, this was written a few days ago, and we learned this morning that the Supreme Court has taken up this decision on their May docket, and so we know that this has already taken place. We at ISRA also have a federal appeal to this unconstitutional semi-automatic weapons ban and high-capacity magazine ban, and we look forward to litigating that in early April. And so right about the same time that they'll be before courts, potentially there'll be a ruling. But with that, I'm going to turn this over to Representative Patrick Windhorst, spokesman of the Jude Criminal Committee.
Thank you. Hi, I'm Patrick Wintour, State Representative for the 117th District, which is all or parts of 10 counties in southeastern Illinois. As many of you will remember, when this bill was being considered for debate, there were arguments made both in committee and on the House floor that the bill was unconstitutional. In fact, a lot of the arguments centered around the constitutionality of the then bill, the now law, that was passed. We had a very short time frame under which this bill was considered and then ultimately came for a vote. And then finally, when it received the governor's signature. From the start of the first hearing on the bill until the governor's signature was approximately 41 days. Since that time, of course, we have had several lawsuits challenging the constitutionality of the law, lawsuits in federal and in state court. The most current, you heard from Representative Caulkins and the success of his lawsuit in Macon County. There was also a lawsuit filed in Effingham County where a temporary restraining order was granted. That was appealed to the 5th District. The 5th District upheld the temporary restraining order, upholding that the law was unconstitutional. That ruling of the 5th District is binding on all trial courts in the state of Illinois until there is a contradictory ruling by another appellate court or by the Illinois Supreme Court. So what we're establishing is there is precedent that this law is unconstitutional from a trial court perspective, from an appellate court perspective, and we will soon have a ruling from the federal courts. Now, despite these rulings, Governor Pritzker and Attorney General Raoul have pressed forward with their messaging that these rulings only apply to a limited number of people, even though the law has been deemed unconstitutional. What we have is a lack of clarity and confusion about what is going on with the status of the law. So the question I have, and I think the question that should be posed to those in the executive branch is the state actively enforcing this law? If they are actively enforcing this law, why are they enforcing a law that courts have deemed as unconstitutional? Even though there are only certain parties to these cases, the Attorney General was involved in the case, the Governor, of course, was involved in the case, and those decisions are binding upon them until a contrary ruling occurs. They should not be enforcing an unconstitutional law, and they need to express, if they are, why they are enforcing that law. So we have argued that the law is unconstitutional. The courts have vindicated that argument to this point. And now those in the executive branch who are attempting potentially to enforce the law with those rulings need to explain why that's occurring. And with that, I'll turn this over to Representative John Cabello.
Thank you. John Cabello, Assistant Minority Leader and State Representative in the 90th District. Been in law enforcement for nearly 30 years now. What we have seen come out of the dome here in Springfield is a direct attack on law-abiding citizens. Law-abiding citizens are going to follow every single law that comes out of here. Who will not? The criminals. The criminals will never follow this law. So if we're doing this to try to avoid criminality, why did we not put in the things that really matter? Why did we not put in things that said, if you're a felon and you're caught with a weapon, there's another enhancement? Why did we not put in a bill that purchasers from straw purchases are going to have another enhancement? We are directly attacking the law-abiding citizens. Now, we've heard that they're not going to enforce some of these laws, but in my neck of the woods, up in Loves Park, we believe that they have been enforcing this law. So we're trying to take a look at what's going on. There's been a gun shop that has been visited by members of the state police, and there is residents that bought weapons that have been visited by the state police. So we need to look into what's going on, because if it's unconstitutional, why are agencies going to look at these folks? This does not reduce violent crime. It does not reduce violent crime at all. We need to look at the actual laws that we can enhance to make sure that our law-abiding citizens are safe. And with that, I think we're opening up to questions.
John, you were right at the mic, and I've got a question for you. And first of all, welcome back.
Well, thank you, sir.
In your police career, you've no doubt